Right, good morning again, everyone who was on promptly at 11. This is Neil Shah, Principal Associate at Mills and Reeve. Charlotte, do you want to briefly introduce yourself?
Yeah, hi, Charlotte Clarke, Senior Associate at Mills and Reeve.
Welcome along to our talk webinar on Remediation Contribution Orders and Building Liability Orders. I'm initially going to talk to you briefly about RCOs as they're better known. Then Charlotte will come and talk to you about BLOs, and at the end we'll probably have a 5 to 10 minutes wrap up where we discuss some of the issues arising from both and some of the things we've seen in practice. I think there is a Q&A box. We're probably going to struggle, given the time restrictions, to get to questions and answers, particularly if you ask us clever questions that we don't know the answer to. But by all means, put anything in there, or if you want to follow up with us after, I think there's a QR code. Please do so, and we'll come back to you with any questions or queries or observations you may have. Right, so without further ado, let's start with RCOs. So RCOs, Remediation Contribution Orders, were brought in via Section 124 of the BSA 2022. I think I'm going to say this is a bit of a refresher for some because I know there's been a huge amount of coverage around this, and there's a decision that will come on to earlier in the year, which I'm sure many of you are familiar with. So hopefully this is a refresher for some more than anything else. Brought in, as I said, via Section 124 of the BSA, with effect from June 2022, like many other parts of the Act, can be brought against. So RCOs, who can they be brought against? Current landlords, but importantly, landlords as at February 2022, if they're different from the current landlords, and or the developer. And what can an RCO be brought for? It's for the cost of remediation works or remedial works. So fairly straightforward in that respect. It's all part of the wider regime, with attributing fault to those who are the ones who caused defects. And Charlotte will come on to the corporate veil and privity of contract and how BLOs overcome that, but RCOs have a similar objective. How can you, or what do you need to satisfy in order to bring an RCO? It's a 5-part test. You need to show that it's in relation to a relevant building. You need to be an interested person. The defect needs to be relevant, and it needs to be a specified body or corporate partnership. And the tribunal or court needs to be satisfied that it's just and equitable in order to make an RCO. Now, there are 2 points there just to note. Interested person, as we'll come on to, it doesn't extend to defendants, whereas a BLO is an interdefendant remedy. And I don't want to spoil Charlotte's talk, but that's something that will become of more interest when Charlotte comes on to speak about that. So if we move on to just briefly what those 5 requirements are. So, sorry, the 5 requirements. A relevant building, just to be clear, is defined as a self-contained building with at least 2 dwellings. It needs to be at least 11 meters high, or it has to have at least 5 stories. That's part 1. Interested person, as I just touched upon, is the Secretary of State, regulator, local authority, fire or rescue authority, or as we see more commonly, or we'll probably see more commonly used, a person with a legal or equitable interest, so leaseholders and the like, as it will come on to in the case that we've seen. And a relevant defect is, as it says there, a cladding or building safety risk defect. It's quite wide in that respect. The specified body or corporate partnership, so this is a person against whom the order would be made, is a landlord, developer, or associated person. Now, that term associated person is probably going to be quite contentious and again is relevant to Charlotte's talk around BLOs. And the final piece that I mentioned was the court or the tribunal need to be satisfied that it's just and equitable to make the order. What just and equitable means is up for debate. Obviously, we've seen that terminology in other legislation. The Contribution Act springs to mind, which I'm sure many on this call will be familiar with. But broadly, although there's no real guidance yet and the case law is limited, no fault is required here and negligence is not required. So, I mean, this is just in keeping with Parliament's objective in terms of this piece of legislation and DULUC's objective, which is those that have the broadest shoulders, I think we all know this by now, should bear the financial burden. So even if there isn't loss, and even if the works have been funded by the Building Safety Fund, that does not prevent the imposition of an RCO. And that brings us on to, sorry, I should say, as I think again most will know, this relates to the the retrospective limitation period for claims brought under the BSA. It can be brought in relation to works that go 30 years prior to the 28th of June 2022. So as the BSA, and again, this isn't new for many of you who will be on this webinar, we could be going back to 1992. So projects previously that you'd considered and have long since been time barred may still now come back into play with claims or applications being made for RCOs. So just moving on, please, to the next slide, triathlon homes. Now, we can't discuss RCOs without talking about this decision, which was in the first tier tribunal. And it's the first, as we understand it, substantively contested decision on RCOs. It involved 5 residential buildings in Stratford. This relates to hence this slide, the Olympic development in 2012. It feels like a long time ago now. An RCO was made in this case in the sum of 18 million, and it was made against both, well, it was made in relation to Stratford Village and Get Living. Now, Stratford Village in this case were the SPV, but the development is now owned by Get Living PLC, and at the time of the application, they're the ones who own the development. Triathlon, going back to the earlier slide, was the leaseholder of the building, and they applied for the RCO. And it was applied against both Stratford Village as the original developer, but importantly, it was also applied against Get Living as the parent company of Stratford Village. And that's quite important because originally, or without something like this, you'd think Get Living may be unable to sort of meet any liability. So interestingly, the RCO, as I said, was made for 18 million, and it was made against both against Stratford Village as the original developer, just to be clear, and also against Get Living as the parent company of the developer. And the remedial works on the building, this is relevant now because the remedial works on the building up to that point had been funded by the Building Safety Fund. And this is relevant because one of the arguments raised by the defendants or the respondents, because it's FTT decision, was around no loss. So Stratford Village argued that there hadn't been a loss here because ultimately the leaseholders and the building owners didn't need to be compensated because they had their loss covered by the Building Safety Fund. So there isn't a loss and there's no need for them to compensate. That was the argument. The tribunal, I think, frankly, this isn't surprising if you look at the intention of the act and the legislation. They dismissed this and they said, none of these points, well, you can see it for yourself, appear to us to provide good reason as to why the respondent shouldn't be subject of an RCO, or justification as why the work should be funded at the public expense. And I think that's an important point here that, as I said at the start, the fifth limb of the RCO test is around whether it's just and equitable to make an order. Now here, the fact that there isn't a loss because it's being funded by the BSF did not make it not just and equitable to make the order. Again, that wasn't considered to be relevant. And also what came out here, and I think this, again, is fairly common sense, but it's clear that the Building Safety Fund is a last resort. I mean, I think it's a bit like a solicitor's compensation fund for those who do those types of claims. Clearly, it's a public person, it's taxpayer-led. If ultimately there is a developer here who should pay, they should pay because this is about non-fault. And that's ultimately what this whole legislation is about, and I think it's embodied here with this decision. So effectively, it was found that it was not just inequitable to allow exactly that best part of 20 million to remain in Get Living's bank account, rather than, returning the money to the BSF. So exactly that happened. The BSF, last resort, this was paid by um, Get Living, which was quite an important and fairly groundbreaking decision, and £18 million is a large recovery. Moving on to the next slide, please. And again, I think we've covered this, but just to reiterate, it's a no-fault remedy. So it doesn't matter if the party against whom the order is being made was not factually the original wrongdoer. So, for example, it doesn't require negligence, and it does not concern itself with the quality of workmanship. The tribunal were also prepared to ignore the absence of a nexus in contract or in tort, which again, not going to come on to Charlie's piece, but it goes to the whole point of the BSA tries to look behind ordinary legal rules like privity of contract or no separate legal personality or piercing the corporate veil. Ultimately, it's about making those who are at fault pay. And that's, I think, what comes out loud and clear. And just to that point, as we said here, the BSA it develops a hierarchy of liability. So ultimately, developers sit at the top, head of the freeholders. You then come on to the landlords. And it's those that have, frankly, the broadest shoulders and the biggest pockets that bear the financial burdens. And the taxpayer should be the last port of call. And again, that point just reinforces there that the fact that Stratford Village was a developer who may have been at fault doesn't mean that Get Living, its wealthy parent company, can somehow just get off it scot-free. So I think that decision was fairly logical. It was quite obviously controversial at the time, given some of the things I've discussed, but I think, broadly followed what the Act was there and what Section 124 is designed at. We do think an appeal had been lodged and a decision's due at the back end of this year, but we are unaware at this stage as to where that's at. But I think watch this space, and if and when that does come out, could be subject of another webinar. But that just sums things up there on RCOs. I think Charlie's now going to come on to BLO. Sorry if I've cut into your time a little bit, but we'll wrap things up at the end with just a general discussion. Over to you, Charlotte.
No problem, Neil. I'm sure we'll be all right. So in that case, I'm just going to talk to you very briefly about building liability orders, as that's quite a mouthful for me. I'm going to refer to them as BLOs. So BLOs came into force on 20th of June 2022 under Section 130 of the Building Safety Act. So a BLO is one of the few situations where the Building Safety Act pierces the corporate veil, looking at a group structure of an entity and making the parent company liable for a liability of a subsidiary. So historically, privity of contract and the corporate personality has been a cornerstone of the industry, which is why this is such a hot topic, because it pierces the corporate veil. So the purpose of the introduction of BLOs are for situations such as and what I'm going to do is this is just a very simple sort of holding company, sister company. Here you can see that normally the claimant would only have a claim for liability against the defendant who actually did the work. So in this case, sometimes you get the defendant company which has the liability, will have no assets, no insurance, or in some cases, a stripped assets because they know of a big liability. We are unfortunately seeing a few instances of companies in the construction industry simply folding because of the current market. So it was also very common practice for developers to set up subsidiary shell companies or what they call special purpose vehicles to carry out these particular construction projects. So these shell companies will have little or no assets themselves. And once the developments are completed, the shell companies are typically wound up and assets are transferred out elsewhere. This makes it almost impossible to enforce any liability or any claims against these special purpose vehicles. And so the developer of these developments has no long-term liability. So a BLO is effectively a court order which extends a relevant liability of a company, so it can also be the liability of an associated company. So both of the companies will then become jointly and severally liable. So this means, as we can see here, that both the holding company or even the sister company of the defendant could become jointly and severally liable for a relevant liability. So what is a relevant liability? It is incurred either under the Defective Premises Act or a liability for a building safety risk, which in this context means, exactly as it said on the slide, a risk to the safety of people in or about a building arising from the spread of fire or structural failure. So what you can see here is that the scope of a BLO is incredibly wide. It's not limited to the height of a building. It's not limited to what's defined as a dwelling. That means it can apply to hotels, hospitals, office blocks, care homes. It also doesn't require that a building is unfit for habitation. It only requires that there's a risk of safety to people from the spread of fire or structural safety. It's not limited, therefore, to fire safety risks, and it can also apply to structural safety risks. And then also note, because of the reference to liability under the DPA, this brings with it the 30-year retrospective limitation period. So incredibly wide application and a lot of situations where these BLOs can apply. So the next point is, when is a company associated with another company? A company is associated with another company if one of them controls the other, or else a third body corporate controls them both. So the first one is sort of a parent and subsidiary structure, and the second one would be a company and sister company type situation. So the test of control is quite complex. I won't go into it in detail. It includes things like majority share ownership, majority voting rights, or as a catch-all, with one company has the power to secure that another company is run in accordance with its wishes. So really quite a general statement there. Also note that a BLO can be made against a parent company if it is currently associated or has at any time in the relevant period been associated with the subsidiary company. Now, note that this relevant period is any time between the start of the works and the granting of the BLO. So the parent company doesn't even need to be currently associated with the subsidiary. It didn't need to be associated with the subsidiary while the development was ongoing, so long as it was associated at any point after the development began. So the last requirement really is that a high court may make a building liability order if it considers it to be just and equitable to do so. As Neil's already explained, the BSA does not define what just and equitable means, so it's going to be interpreted on a case-by-case basis. So we've seen the recent case of Wilmot Dixon v. Prater, where a defendant brought a BLO against another defendant in Part 20 or contribution proceedings. The court then gave some useful guidance on the granting of a BLO, such as the fact that it can be just and equitable to grant a BLO even if the primary company has disposed of assets innocently. So there's been, for example, no asset stripping. Again, this remedy doesn't require fault or wrongdoing on the part of the original insolvent company or its parent. So it's also not a requirement that the primary company has failed or is unable to pay. This is because this liability is joint and several, so it's casting the net as wide as possible, regardless of whether or not the subsidiary company is unable to pay. It's still going to cast the net to a parent company or a sister company, and it's joint and several liability. So an this means all of the above actually means an associated parent company can be held jointly and severally liable, even when it wasn't involved in the original project, even if it didn't even exist at the time, and even where it might not be in the same jurisdiction. So once again, this net is incredibly wide. And you know what, with the way that the construction industry is going at the moment, we know that there's a lot of instances where sort of contributions would be claimed against other wrongdoers in a project. For example, if you wanted to sort of ensure that liability is passed on to the responsible parties, if that responsible party no longer exists, has sold its assets, or has shut for completely legitimate reasons, there is often a group structure available, whether or not that group structure is even resident in the UK or not. Either way, those options are available. And I think the purpose of these provisions are to ensure that liability, that first of all, that these buildings are remediated, obviously, but also to ensure that the industry, the cost of remediations are shouldered by the correct people and shouldered by the people who are able, in fact, to assist in the cost of these remediations. And I think Neil probably has some questions for me, which we were discussing earlier, and I hope I can answer.
We've done well there on timing, actually. Yours
Good.
is incredibly succinct. Yeah, we did. And there's a couple of things, Charlie, like what you've talked about at the BLO, that the main thing in terms of it being different to, one of the main things in terms of being different to an RCO is, for a lot of people on this call, it's interdefendant, right? So it can actually, as it was used here in that judgment you've just talked about, be used between defendants, which is naturally a good thing from
Yeah,
a defendant insurer's perspective.
I think that's definitely why it's such a hot topic at the moment,
Mm,
because following the Wilmot Dixon case, that was the first case actually where it was defendant against defendant
exactly.
ordering
Yeah.
a BLO. And I
Yeah.
think what's really interesting here is that it's opened up the fact that if you're looking for contribution for these type of risks, for something that falls into, say, it doesn't even have to be DPA, building safety risks, that option is open to
Yeah.
you to bring a BLO against anybody else and any other defendant and their parent companies, especially if you're concerned that the defendant that you're in proceedings with, or that you're in Part 20 proceedings with, might end up folding or might not have the funds to fund these kind of claims.
And I think that was obviously a key part of the decision-making process in that case that we've talked about just now, wasn't it?
Yeah, and I think it's what you were saying about RCOs, where
Mm,
it's those with the biggest shoulders need to
yeah,
shoulder these burdens. And I
yeah,
thought that was quite interesting because, I think you'll probably find a lot of parent companies don't like the thought of this. A lot of group structures, as I said, privity of contract and
exactly.
you know,
Yeah,
corporate structures. So, I mean, when it comes to RCOs, the fact that it's not going to be who's the most at fault, right? It's who can pay.
exactly. Yeah. And I think that's that. I mean, to me, I know everyone's got a different view, but it makes sense in some respects because that's what this is about, really, isn't it? And it's about keeping it away from the government and from the taxpayer and making those who previously hid behind these corporate entities and structures cough up. One thing I was going to say, and this is another piece on your bit and talking about interdefendant stuff, Charlie, is that this is probably in some cases better than the equivalent as a parent company guarantee, right? That we see in a lot of contracts, and I'm sure we've probably all sought to rely on in the past, where the actual contracting entity is for whatever reason unable to pay. You go after the parent, but often those contracts and the PCGs are negotiated quite narrowly where this is a lot wider. Do you think that's probably fair? I mean, I appreciate it depends on what the PCG in each situation says, but that's sort of my experience.
Absolutely, and there are
Mm.
arguments that these parent company guarantees are
Yeah,
sort of they're not required anymore in light of the
yeah,
DPA. There are
yeah,
obviously those arguments, but we found that really the purpose of the BLO is to give a much wider,
exactly.
call it a parent company guarantee,
Yeah,
which just ensures that so special purpose vehicles or shell companies aren't used to evade liability.
Exactly.
As I've said, it's lovely when it comes to when it comes to sort of reclaiming claims or subrogation or anything like
Yeah,
that, because
yeah,
you have a much wider net
yeah,
in which to,
yeah.
or let's say a much bigger pond in which to fish.
Agreed. So, I mean, from the majority of people on this call, probably, potential insurers, it's just another means through where the BSA, whilst obviously is not considered probably, it's detrimental in some respects in terms of potential liability, but it allows you to look at like Section 149 and 150 against manufacturers. It allows you to, like you say, cast the net slightly wider when you're looking at recovery actions, and it gives you other routes that previously pre 2022 didn't exist.
Exactly.
Yeah,
Exactly.
cool, cool. And one thing just generally around both that we talked about, and we're going to dodge the question because it's all dependent upon what the particular policy says, but both of these types of orders or these remedies raise quite a few coverage questions, to say the least. Is that fair?
Absolutely. And I think
Yeah,
that's something I wanted to, the fact that RCOs require no fault,
mm,
whether or not that's going to have any impact on
yep,
policy response, especially when a PI policy usually requires negligence or at least an
yep,
allegation of negligence. As I said,
agreed.
it's not something we're going to get into here, but it
No,
is definitely
no,
something to consider because an
no.
RCO is a no fault remedy.
Yeah, and I think that, without going into the detail, we'll see policies trying to specifically deal with these going forward, with endorsements and the like, if we haven't already. Um, I think one final thing to say on that is as well, as we see here, the liability could attach to the parent company, who, like you say, had no fault and was in no way responsible for the underlying project. Query whether they're going to be insured under the policy or whether there's a separate master policy, etc., etc. So it raises other interesting insurance questions around that aspect as well, I anticipate.
Yeah, I think that's the only thing, if that's a takeaway from this, is
Mm.
to examine sort of things like group policies and
Yeah,
examine insurance policies and see if there are any parent companies or if any parent companies have any subsidiaries with possible
yeah,
liabilities, because that group structure is unfortunately no longer sacred. And it's definitely something, it's to consider whether parent companies need to be notified and how, in fact, insurers are going to deal with these liabilities where it's within a group structure.
yeah, agreed. So if you could give your takeaways from your part in 30 seconds, putting you on the spot.
50 seconds, that's really quick. So I think the most important takeaway is that these applications are incredibly wide. The order is joint and several liability, and it can be
Mm,
brought defendant to defendant. So in
yeah,
actual fact, while it seems quite scary, it's probably going to assist with claims and Part 20 contribution claims,
agreed.
in the end.
And sorry, I've put you on the spot there because we didn't rehearse that
That's
bit.
fine. I
But
will do the same to you,
yeah,
Neil. Give us your takeaways on remediation
I knew
contribution
that
orders,
was I
please.
knew that was coming. So I mean, the main difference is probably here, as we say, it's leaseholders and claim and developers that leaseholders as opposed to interdependent. So it's not as wide in that respect. Again, it's got the 30-year retrospective, so we could be going back to 1992. Again, the main point is no fault, and it doesn't matter if you weren't responsible for it. Ultimately, the overwhelming thing is the broadest shoulders. Those who have the means to pay should pay, and that's the whole purpose of the legislation. And I think the triathlon judgment reinforces that. And don't think that because it's actually being funded by the BSF, you're going to get off scot-free, because you're not. So it's hopefully, if it continues to work in the way it's intended, it allows potential route through that, depending on which side of the fence you sit, obviously. I think we've overrun time as would be
Yeah,
expected, but that's
unfortunately, I
probably
think
more
we
from the general discussion, because you can talk all day about these things. If anyone does have any queries or questions, please feel free to get in touch with us. Our details are there. All that's left to say is thank you all for joining. Charlie, probably leave you
yeah,
to say the same.
yeah. Thanks for listening, guys. And
Thanks
once
so
again, any
much.
questions? Bye.
Cheers.